Are you worried about jeopardizing your spouse's visa petition? Are you aware of the common mistakes that could potentially derail your application process? Well, let's clear the fog. Welcome to Direct U.S. Immigration's channel, where you get direct access to our most up-to-date immigration and global mobility space. I'm an immigration attorney with almost a decade's worth of experience, and today we're going to talk about the top 5 mistakes that can ruin your spouse's visa petition in 2024. Stay tuned. Thanks for tuning in. My name is Maitreya Brown, and I'm a U.S. immigration attorney based in Washington, D.C. I'm also the principal attorney at Direct U.S. Immigration, where we work with clients in all 50 states and around the world. Before we start, click on the like and subscribe button to follow our Immigration Hub to get the latest immigration information that could be vital to your case. And also, be sure to stick around until the end to get a bonus tip on how you can prove that your marriage is in fact real. As you may already know, if you're planning to help a spouse immigrate to the United States, you'll likely need to file Form I-130, which is the Petition for Alien Relative, and potentially Form I-130A, which is the supplemental information for a spouse beneficiary, with USCIS. It's the start of an immigration journey that won't always be straightforward, so it's wise to educate yourself on the process and requirements to minimize potential problems that result in delays. After all, quick approval of the spousal petition aims to help your husband or wife immigrate. So here are 5 problem areas to pay attention to as you prepare the petition. So the first is insufficient evidence of a bona fide or true marriage. So when you file a spousal petition in furtherance of a green card, you must also submit several supporting documents. This includes any documentation that backs up the facts that you are stating on the I-130 petition. When petitioning a spouse, it's not adequate to submit only a marriage certificate to prove the merits of the marriage. USCIS wants proof that you have a genuine relationship that was entered into to spend your lives together. The burden is on the petitioner to prove the bona fides of the marriage. USCIS is always on the lookout for potential green card fraud, and it is fraudulent to get married for an immigration benefit. Therefore, USCIS wants to see that the married couple is truly in it for love. Now, the second is failing to document the termination of a previous marriage. So you'll need to prove that you have a genuine marriage, and you'll also need to prove that you terminated any previous marriages. So if either you or your spouse were previously married, submit copies of documents showing that all prior marriages were legally terminated. Now, examples of acceptable documents include a certified copy of the divorce or annulment decree, or a copy of the death certificate if the marriage was terminated due to the death of a spouse. When preparing Form I-130, you'll need to supply these event dates. Don't guess, so get a copy of the document to provide an accurate answer. If you've lost the decree or certificate, you may generally request copies of these vital records from the court or local government offices where it occurred. Now, third is omitted or inaccurate information. When you file a spousal petition for a green card, you must take the time to ensure the information you provide is accurate and complete. Discrepancies, inaccuracies, and outright omissions can sometimes lead to serious problems. Misrepresentation from the green card process can be catastrophic for the beneficiary. In other words, it can lead to the spouse getting a denial and potentially being permanently barred from the U.S. Now, there are situations where incomplete or inaccurate information can be acceptable. So, for example, you may not remember the exact date you started a job because the company is no longer in business, or you're unable to contact previous workers, and you no longer have your onboarding documentation. And in this type of situation, you can provide your best estimate so long as it is truthful and provide notation in the addendum regarding the situation. But other times, inaccurate information can be costly. So if you're not sure, ask. Now, fourth is filing for an undocumented spouse. It may or may not be advisable to file a petition for an undocumented spouse. Now, this depends on several circumstances. When using the term undocumented, I'm basically describing somebody who is physically present in the United States without lawful immigration status. So being undocumented can generally happen in two different ways. The person may have entered unlawfully because he or she never had permission to enter the U.S., or alternatively, a person can enter with a valid visa or parole that expires. If the visitor never leaves, they also become undocumented. Now, this distinction is important when applying for a green card from inside the United States. So to file Form I-45 to adjust status to permanent resident, or to a green card holder, the beneficiary generally must have a lawful entry into the U.S. In other words, the beneficiary must have entered legally, even if that status has expired. Individuals without a lawful entry should expect a different and potentially more complicated process that may require a request for an I-601A waiver with the assistance of an attorney. Now last, number 5 is falling out of status. Now depending on the status of the U.S. sponsor, once you filed the spouse petition for a green card, it may be necessary for the intending immigrant to maintain status. Now let's talk about filing a standalone I-130. So when a U.S. citizen or lawful permanent resident files that Form I-130 petition for a spouse, it does not trigger any immigration status for the beneficiary. The beneficiary doesn't gain immigration status when USCIS approves the spousal petition either. So the petition only establishes a qualifying relationship and reserves a visa number. The immigrant visa and status are not available to the beneficiary until the government grants the immigrant visa or that green card availability. If your spouse is in the U.S. with non-immigrant status, they must maintain it, though exceptions do apply for U.S. citizen sponsors. Now let's talk about the concurrent filing of Form I-130 and I-485. So if your spouse is eligible to file the petition concurrently with the green card application, there's less of a need to maintain a non-immigrant status if the sponsor is a U.S. citizen. But it is a smart approach to keep status if possible. Now, when USCIS accepts an adjustment of status application, the beneficiary becomes an adjustment of status applicant with the legal right to remain inside the U.S. The beneficiary may not be required to maintain his or her previous non-immigrant status, but there are advantages to keeping in status. So, for example, a beneficiary visiting on a B2 visa cannot extend that status. He or she would have to recommit to a non-immigrant intent, and this would be a misrepresentation because the beneficiary, in fact, intends to immigrate at this point. So in this case, it is not appropriate to extend that B2 status when adjusting status. Now let's talk about a client success story. So meet John and Miha, a loving couple who had just embarked on their journey to secure a marriage-based green card. They were both excited and nervous about the process, knowing that every detail mattered. However, they overlooked one crucial detail that could have cost them their dream. So John, an American citizen, and Miha, originally from Sudan, lived in New York, but Miha had been working in Minnesota. In the hustle of compiling their paperwork, they accidentally swapped the dates of where they lived and where Miha worked. And the discrepancy was glaring. According to their application, they were living and working in different states at the same time, but she was not working virtually. So the day they received a request for evidence, which is also known as an RFE, from USCIS was a day that sent chills down their spines. The RFE pointed out the discrepancy in their application, and their hearts sank as they realized their simple oversight could result in a denial of their application. However, they were in fact fortunate. So USCIS had noticed the discrepancy, but had given them an opportunity to explain. Now, not all applicants receive this leniency. Some officers assume misrepresentation or fraud is afoot and will issue a notice of intent to deny. John and Miha quickly gathered evidence to prove their actual living and working arrangements and submitted it promptly. Weeks later, they received the news that they had been eagerly waiting for. Their I-130 application had been approved, and the next step was the green card interview. The relief and joy they felt were indescribable. Now, despite the stressful period, they were grateful for the chance given by USCIS to rectify their mistake. John and Miha's story is a lesson to all applicants about the importance of double-checking every detail in your application. A simple error can lead to complications, and not everyone may get a chance to explain. But with careful attention to detail and a bit of luck, hurdles can be overcome and dreams can come true. Now, as promised, here's some bonus information that you may not know about. Now, let's talk about the evidence that you can show that you live together. Now, USCIS expects married couples to live together when feasible. For more typical cases, examples of documents that can help prove cohabitation or living together include copies of the following showing both spouses' names. So a joint mortgage or lease documents, and make sure to include a copy of the entire mortgage or lease. Utility or other bills showing both spouses' names. Property deed. Now, copies of the following showing the same address for both spouses is helpful. The driver's license, property deed, insurance statements, or joint bank statements. Now, original copies of the following showing the same address for both spouses are also helpful. And that includes letters from family members, friends, and/or employers. Now, last but not least, be sure to check out the caption below this video. We've got questionnaires for different types of visas so that we can help you determine which visa is most appropriate for you. And if you're traveling soon, we also have a list of some of my travel favorites. So I hope you found this video helpful. Subscribe if this content or information helps you in any way. Comment below if you want me to talk about something in specific. And share this resource widely because you never know who needs answers to these questions. Additionally, if you have any specific questions about this video as they pertain to your unique circumstances, please schedule a consultation with us, also at the link below, and I'll see you in the next video.